Good evening, everyone.
Okay, so sir, today is session 5 of law internship, right?
Right, ma'am.
Okay.
So,
Okay, sir. So we can
good
start.
evening, everyone. Today we will be going and reading about the Constitution of India. So, I am sharing my screen. I hope it will be visible to all. Good evening, everyone. Today we will be discussing about the Constitution, law, and fundamental rights. The Constitution of India. We will be studying today background, significance, and structure, and various other laws which are basically structured upon Constitution of India. So basically, it was adopted on 26th of November 1949. It was enforced on 26th January 1950, the day we celebrate as a Republic Day. It was drafted by a Constitution Assembly during the period of 1946 to 1949. The chairman of that committee was Mr. Dr. B.R. Ambedkar. Originally, when it was drafted, it was consisting of 395 articles, but currently it has 448 articles. Schedules 8 originally, now it has 12 currently, and the amendments which has happened to the constitution are 106 in number as of 2024. It is the world's longest written constitution. Supreme law of land. Constitution is a supreme law of land. All legislation must conform to it. Establishes the structure of three organs of state, guarantees fundamental rights to every citizen, lays down directive principles for governance, contains provisions for amendments, living document, preamble declares India as a sovereign, socialist, secular, and democratic republic. Yes, Aradhya?
Sir, actually, could you check your voice? It's getting a little break.
Now it is audible to you properly.
Yes.
We can continue now. What is preamble in Indian constitution? Can anyone wants to tell me? Yes, Aradhya?
Yes, sir. So, preamble is basically, we can tell that preamble is a kind of a part of Constitution of India, acting as a summarization of Constitution of India and declaring the fundamental objectives upon which the Constitution is drafted and what does it provide to public in terms of their rights.
Okay, fine. Basically, if we read the preamble, it says the preamble is a introductory statement. I'm explaining the preamble. It is an introductory statement of the constitution. It declares the source of the constitutional authority, the people of India, and its objects. Although the preamble is not itself enforceable in court, it is key aid to interpreting the constitution. ठीक है? Thereafter, we will read the preamble. We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, and democratic republic, and to secure to all its citizens justice, social, economic, and political liberty of thought, expression, belief, faith, and worship. My voice is audible to everyone?
Yes, sir.
Yes, Suhana, say.
So your voice is audible, and preamble is the starting page of the constitution.
Yes, I told na, it is basically an introduction to the constitution. Anyone else has also raised the hand? Basically, talking about the constitution, the structure of constitution is in the following form. It has been divided in various parts. So, part 1 consists of part article 1 to 4, name and territory of the union. Part 2 consists of article 5 to 11. It consists of citizenship rights and article based on that only. Part 3 consists of article 12 to 35, that are fundamental rights, the most important section of for this today's session. Part 4 consists of article 36 to 51, directive principles of state policies. Part 6A, article 51A, which was inserted in the constitution after an amendment. So those are fundamental duties added by 42nd Amendment in 1976. Part 5 consists of Article 52 to 151, the Union, President, Parliament, and Judiciary. It talks about President, Parliament, and Judiciary. Part 6 consists of Article 152 till 237. It talks about the states, the powers of the states. Part Then 14 talks about Article 308 to 323, services under union and states. And then part 18 talks about Article 352 to 360, emergency provisions. So basically, if we talk about I will come to this later, but now we will start again with the preamble. So I have already told you the preamble is an introductory statement of the Constitution. It declares the source of the Constitution's authority and its object. Although the preamble is not itself enforceable in court, it is key aid to interpreting the Constitution. And there was one very celebrated judgment you all must have heard about, that is Keswanan Bharti. The Supreme Court held that preamble is a part of Constitution. Prior to that, it was not clear whether the preamble is part of Constitution or not. But after this judgment, it was made clear that the preamble is part of our Constitution. So the key words of the preamble are sovereign. What is sovereignty? Sovereignty means the state is independent. The state consists of, it can be state like union or state. India is independent. No external authority can override India's decision. This we call sovereignty. India can make its own laws and treaties without any other nation's permission. So this we call sovereignty. हमारे को किसी के डिसीजन की जरूरत नहीं है, किसी की परमिशन लेने की जरूरत नहीं है फॉर मेकिंग एनी लॉज इन आवर कंट्री. सो दिस वी कॉल्ड sovereignty. So India is a sovereign country. Now socialist. This is the state ownership of key industries, reduce inequality of income and status. This was added by 42nd Amendment in 1976. Interpreted flexibility includes welfare and state policies. Prior to this, this word was not inserted in the preamble. Socialist. It was added after 42nd Amendment in 1976. Secular, no state religion. All religions treated with equal respect by the state. Added by 42nd Amendment in 1976, the state cannot discriminate on the basis of religion. So these two things were added after the amendment. Now, democratic. India is we call every time we call and that India is a democratic country. Why we call it a democratic country? Because citizens elect representatives, minorities are protected, and rule of law applies equally. Government is elected by and accountable to the people through free and fair elections. Republic. Now we talk about republic. Head of the state is elected by the people of the country. Thus, president, not hereditary, no monarchy system. Like you must have heard about North Korea, where today also the monarch system prevails. Even there is a country called Thailand. There is also monarchy system, and Indonesia there is also a monarchy system till today. So in India, president is elected by the electoral college, not hereditary position. Justice. There are three kinds of justice. Those are social, economic, and political equality and fair treatment for all the citizens. Liberty, freedom of thought, expression, belief, faith, worship is guaranteed to all. Citizens are free to think and express themselves within the constitutional limits. Equality, equal status and equal opportunity for all citizens. No discrimination, equal protection of laws regardless of the background. Fraternity, brotherhood, and solidarity among all citizens, assuring dignity of all individuals and unity and integrity of India. So this we have discussed about the preamble. If anyone has any doubt, then we can discuss. Yes, Aradhe. One more thing I want to make clear here, that prior to basically when the constitution was enforced, I already told you that socialist and secular and integrity were not in the original preamble. When it was enacted and adopted, they were added by the 42nd constitutional amendment in 1976 during the emergency period under Prime Minister Indira Gandhi. The original preamble only reads about sovereignty, democratic, and republic. Yes, Aradhya, say.
So, is my voice clear?
Yes, your voice is clear.
तो सर लाइक आई वांटेड टू, मुझे जनरली एक चीज़ पूछनी थी कि जैसे हम लोग क्लाट वगैरह की प्रिपरेशन कर रहे हैं, तो उसमें भी कॉन्स्टिट्यूशन हैव अ वेरी इंपॉर्टेंट रोल इन द सेट करिकुलम। सो लाइक मैं एक नॉर्मली क्वेश्चन था कि सर जैसे हम पार्ट 3 to 4 तक तो मोस्टली याद रह जाता है, बट वी कैन नॉट रिमेम्बर पार्ट्स अहेड ऑफ इट, सो एनी स्पेसिफिक वे टू रिमेम्बर देम?
Basically, there is no specific way. You need to put more your focus on the fundamental rights. What are fundamental rights? So this is the most important aspect which we need to remember is about all the fundamental rights, directive principles. These are most important, which are asked during the competitive exams. So make sure that you read thoroughly what Constitution talk about fundamental rights. There are few decisions also which we will discuss during this session only. Those
Got it,
decisions
sir.
are very
Got
much
it.
important.
Got
Those
it, sir.
decisions are also very much important. Judgments we will discuss at the
Thank
later
you,
stage.
sir. Thank you, sir.
So now we will talk about part 3, fundamental rights. So can anyone tell me first about the fundamental rights? Yes, Aradhya.
So fundamental rights are basically those constitutionally guaranteed rights that are formed under the basis of the fundamental like fundamental principles of life, and they are those rights which like maintain human dignity and ensure equal protection, and hence they can be enforced by Supreme Court and High Court.
Anyone else? Basically, fundamental rights are guaranteed by part 3 of the Constitution. Those are Article 12 to 35 of the Constitution. They are enforceable in courts. A citizen can go directly to the Supreme Court under Article 32 or High Court under Article 226 if these rights are violated. The rights bind the state defined under Article 12 to include the union, states, local bodies, and other instrumentalities of state. They are not absolute. Reasonable restrictions can be imposed when these restrictions can be imposed during emergency period. Now we will discuss that at a later stage. Now we will discuss Article 12. What is Article 12? Article 12 talks about definition of state. State includes the government of India, parliament, state governments, state legislatures, and all local and other authorities within India. This is critical. Basically, fundamental rights are enforceable only against the state and entities that are instrumentalities of the state, not generally against private individuals. Always remember when you file a petition before the High Court or Supreme Court for violation of your fundamental rights, you cannot enforce any private party to that petition. You can only make a party that is a state. It can be union body or a state body, or which comes under the power of union or state bodies, not a private party. Now, right to equality, Article 14, equality before law. The state shall not deny to any person equality before law or the equal protection of the laws within India. This applies to both citizen and non-citizens. Equality before law is borrowed from the English law, common law. Dicey rule of law. Equal protection of the laws is borrowed from the 14th Amendment to the US Constitutional. It was adopted from the US Constitution. ठीक है, की डॉक्ट्रिन क्या है इसके अंदर हमारा? इंटेलिजिबल डिफरेंशिया. आर्टिकल 14 डज नॉट मीन ऑल पीपल मस्ट बी ट्रीटेड आइडेंटिकली. द स्टेट कैन क्लासिफाई पीपल इनटू ग्रुप for different treatment. First, the classification is founded on an intelligible differentia, a real difference, and two, the differentia has a rational relation to the object sought to be achieved by law. Basically, you know about the reservation also. So, if we say that whether in India we have right to equality, no, we do not have, because state has chose certain people and given them reservation so that they can come forward, because we consider them nowadays, nowadays or earlier also we consider them backwards. So that is the reason we gave them reservation, so they can compete with the other society, other parts of the society. So it does not mean that everything is equal. So there are certain sections of the society which are given preference over the general law, general citizens. That is the reason there are caste system. We have divided the general and other backward classes, scheduled classes, scheduled tribes, and other backward classes. Article 15, prohibition of discrimination. The state shall not discriminate against any citizen on the grounds only on religion, race, caste, sex, or place of birth. Note the word only. Discrimination based on multiple grounds or legitimate reasons may be permissible. Article 15.3 talks about exception for making special provisions for women and children. If you will go through IPC also, you will IPC or CRPC, you will found that there are various exceptions made for the child as well as for the women. So it is permissible under Constitution. Article 15.4 talks about exceptions for advancing interest of socially and educationally backward classes or scheduled caste, scheduled tribes. Article 15.5 talks about exception for reservation in educational institution. This was added by 93rd Amendment in 2005. Article 15.6 talk about 10% reservation for economically weaker section EWS, added by 103rd Amendment in 2019. Anyone have any doubt, then we can discuss that doubt right now. Otherwise, we will move forward to Article 60, because you people can raise a doubt that एक सर इक्वलिटी तो यहाँ पे हुई नहीं, क्योंकि वुमेन्स के लिए लॉज अलग हैं, बच्चों के लिए लॉज अलग हैं, डिफरेंट सोसाइटीज के लिए लॉज अलग हैं. बट कॉन्स्टिट्यूशन हैज गिवन अस पावर टू मेक लॉज with certain exceptions. Yes, Rohan? Rohan, your voice is not audible. Rohan, your voice is not audible. Now we will be moving to Article 16. Equality of opportunity in public employment. Rohan, do you have any doubt? Because
Yes,
your voice is...
yes, sir, I
Your-
had a doubt, but I was not able to unmute. Sir, my doubt is, why are there many articles for only one right? Sir, like for right to equality, why are there 4 articles from 14 to 18?
Can you come again? I did not understood what you are saying.
Sir, I'm asking, what is the purpose of many articles? Because
Because every article talks about different rights.
No, sir,
Everything has not been discussed under Article 14 or Article 15. Article 16 talks about public employment. Article 17 talks about abolition of untouchability. Article 18 talks about abolition of titles. That is the reason there are different articles.
okay, sir, thank you.
Yes, Rohan?
Sir, I said thank you.
Okay, fine. Mishika? Mishika, your voice is not audible.
Sir, I am audible now.
Yes, you are audible now.
Sir, I wanted to ask that in India we don't mostly follow equality, but we rather follow equity. So why isn't it explicitly mentioned in the constitution?
What is not mentioned in the Constitution?
That like in India we follow equity rather than equality. So why isn't that mentioned in the
So that is the
constitution?
reason there are exceptions. The Constitution specifically mentioned about the exceptions to it. What exceptions can be taken by the government while enacting a law? I already told you, there are, if you will go through the laws, whether it is IPC, CRPC, or even CPC, there are exceptions to the law. That is the reason it has been mentioned in the articles only.
Okay, sir. Thank you.
Now, Article 16, equality of opportunity in public employment. No citizen shall be discriminated against in matter of public employment on ground of religion, race, caste, sex, descent, place of birth, or residence. Allows reservation for backward classes, SCs and STs in government jobs. So this is clear to everyone. कोई भी job हो in public employment, you cannot discriminate a citizen during employment. Now, Article 17, abolition of untouchability. Untouchability is abolished and its practice in any form is forbidden. The enforcement of disability arising out of untouchability shall be an offense punishable in accordance with law. The Protection of Civil Rights Act 1955 was enacted to give effect to the provision. Everyone is aware about that you cannot practice untouchability. You cannot, earlier we used to call it छुआछूत. But अब वो after enforcement of the constitution and the articles. Yes, Mishika, you have any doubt?
No, sir. Sorry, I forgot to lower my hand.
Totally fine. So you cannot do untouchability for anyone, whether it is a scheduled caste or scheduled tribes. It is offensible under law. There is specific laws regarding that. We have SC/ST Act, which is very much deterrent, very much strict. Article 18, abolition of titles. You know what is titles? Can anyone tell me what is title? Can anyone tell me what is title? No one knows what is title. So basically, for giving an example to you, in England, we give a title of sir. You must have heard about Alistair Cook. So we call him Sir Alistair Cook. So this is a title given by the government of UK to Alistair Cook. So this is an example of title. In India, earlier also there were titles like Raja, Raja Sahab, Zamindar. These all were titles which have been abolished after the constitution. No title except a military or academic distinction. In military, there are titles like major, brigadier, but other than that, you cannot confer with any title. No title shall be conferred by the state. No citizen shall accept any form of title from any foreign state. National awards like Bharat Ratan do not constitute titles. Held in Balaji Raghavan, this is a judgment wherein it was held that the Bharat Ratna, Padma Vibhushan, all the awards given by the state or government do not confer any title to any person who is receiving the award from the government. Now, Article 19 to 22, right to freedom. 19(1)(a) says speech and expression, sovereignty, integrity. Speech and expression. 19(1)(b) talks about assemble peaceability and without arms. You can assemble anywhere without arm. 19(1)(c) talks about form associations or unions or cooperative society. 19(1)(d) talks about move freely throughout the territory of India. 19(1)(e) talks about reside and settle in any part of India. Aradhe, we will take your doubt later. Let me read it first. 19(1)(g) talks about practice any profession, trade or business. 19(1)(f) talks about the right to acquire, hold and dispose of property was deleted. It was deleted from the constitution by the 44th amendment in 1978. Property rights were removed from the fundamental rights and are now only a constitutional right under Article 300A. Yes, Aradhe, you have raised your hand. Aradhe, do you have any doubt? Now we will continue again. Article 19 we are discussing right now, which guarantees 6 freedoms to citizens, not to non-citizens. This freedom is only available with who are citizen of this country. So again, I am reading it. Article 19, clause 1A. Speech and expression. Article 19(1)(b) talks about assemble peacefully and without any arms. 19(1)(c) talks about form associations or union or cooperative society. 19(1)(d) talks about move freely throughout the territory of India. Article 19(1)(e) talks about reside and settle in any part of India. Article 19(1)(g) talks about practice any profession, trade or business. And 19(1)(f) was deleted from the constitution. So what are the restrictions which have been imposed? If we talk about Article 19(1)(a), you cannot discuss about sovereignty against the India. You cannot discuss make any comments against India, against sovereignty of India, integrity, security of state, public order, decency, morality, contempt of court, defamation, incitement to offense. So there are various restrictions also which have been imposed in the Article 19. There is a very thin line. You must have heard about a law sedition, which have been now changed after coming into effect of BNS. So there is a very thin line between the fundamental rights, what is right and what is wrong. You must always take care what you are talking about, what you are expressing, because nowadays people have been arrested by the government for violating certain security issues or various other things done by the citizens of this country, due to which they are taken into custody. So you must always take care what you are speaking. It does not mean that you can say anything. You must think before speaking. Article 20 talks about protection in respect of conviction of offenses. There are three protections against criminal prosecution. No ex post facto law. A person cannot be convicted for an act that was not an offense when it was committed. No double jeopardy. No person can be prosecuted and punished for the same offense more than once. No self incrimination. No person accused of an offense shall be compelled to be a witness against himself. Now, who will tell me? I have read, I will come again. No ex post facto law, no double jeopardy, no self incrimination. कौन मुझे बताएगा इन तीनों का मतलब क्या होगा? Can anyone tell me? There are 31 participants as of now. Can anyone tell me? At least make an effort to tell me whatever comes to your mind. Yes, Aradhe, say.
So, like as you asked, so I don't know about ex post facto law, but I know that about double jeopardy and
Yes.
self-incrimination. So, double jeopardy basically says that nobody can be convicted for the same offense two times. Like if somebody is already convicted for a charge of sedition, then he cannot be convicted again for the same charge. And secondly, talking about self-incrimination, it is that one cannot be like compelled, or one cannot be like yes, one cannot be compelled to witness against himself in certain cases, like talking that yes, I have done this crime, and they have all the right to like remain silent and ask for a legal professional.
Okay, fine. So talking about no exposed. Yes, Swana. Swana, unmute yourself. Voice is not audible. Swana, your voice is not audible. So talking about no ex post facto law means if you have committed, today we cannot say call it as an offense because it does not comes under the category of offense. But tomorrow it comes into the category of offense, then you cannot be prosecuted for that because that was not an offense on that day. अगर आज लॉ में अगर कोई चीज आप करते हो और वो गलत है एंड एज पर लॉ इट इज बीइंग कैटेगराइज्ड अंडर द कैटेगरी ऑफ ऑफेंस, देन ओनली यू कैन बी प्रोसिक्यूटेड फॉर दैट. अगर सपोज मान लो कि आपने आज मेरे को 1 लाख रुपए ट्रांसफर करे एंड इट वाज नॉट required to pay any taxes for that. Tomorrow a law comes into force that if you pay certain to something to someone and you are liable to suppose we deduct TDS. Suppose आपने मुझे 1 लाख रुपए पे करे and you were not supposed to deduct anything as per the law, but tomorrow the law comes into enforcement कि if you transfer 1 lakh rupees to someone then you have to deduct TDS of 10%, but you did not deduct it. So tomorrow the tax authorities cannot compel you to deduct the TDS and categorize it under the category of offense. So this we call no ex post facto law. You have already discussed that no double jeopardy. Basically, a person cannot be prosecuted and punished for the same offense more than once. And suppose the example of it is, suppose you commit an offense and there are several FIRs. You must all are aware about the Samay Raina, his show that was latent. So उसमें क्या हुआ था कि there were many FIRs. There were FIRs from the state of Assam, FIRs from the state of Maharashtra, and various other FIRs also was registered against him. So that does not mean he will be prosecuted for many times for all the FIRs. So all the FIRs can be clubbed together and he will be prosecuted for those FIRs only once, not for several times. And only once punishment will be given to him, not many a times. So now it is clear. And No self-incrimination, that means you cannot be a witness for your own wrongs. आप अपने आप में गलत किया, आपको कोई कंपेल नहीं कर सकता आपको जाके बोलो कि मैंने गलत किया है। कोर्ट में आप जाके अपना विटनेस खुद नहीं बन सकते, या कोर्ट आपको कंपेल नहीं कर सकता कि यू बिकम योर ओन विटनेस एंड कन्फ्रंट दैट यू आर रॉन्ग. So that means no person accused of an offense shall be compelled to be a witness against himself. So this is clear to all now. Now moving to Article 21. This is the most important article, that is right to life and personal liberty, which talks about no person shall be deprived of his life or personal liberty except according to procedure established by law. This is arguably the most important fundamental rights. The Supreme Court has read into Article 21 an enormous range of rights. That Article 21 cover these rights now, which I will talk about. That is right to livelihood. It was discussed in the judgment called Olga Tellis versus Bombay Municipal Corporation in 1985. Right to health and medical aid, right to clean environment. That is the case which we discussed. That is MC Mehta case. Right to education, right to speedy trial, right to legal aid, right to dignity and protection from torture, right to privacy. This was the recent judgment, which was, I think, in 2017 or 2019, which is known as Puttaswamy judgment. Right against sexual harassment at workplace, that is Vishaka. It was decided in 1997. There is one more judgment which is very much important. So that is you all must have heard about this judgment. That is Menka Gandhi versus Union of India. Before
Yes,
Menka
sir.
Gandhi, courts interpreted Article 21 narrowly. The state could deprive life, liberty by any procedure it chose. In Menka Gandhi, the Supreme Court held that the procedure must be fair, just and reasonable and not arbitrary. This judgment transformed Article 21 from a procedural guarantee into a substantive right. So now we will discuss about Article 21, right to education, which was added by the constitutional amendment in 2002. It was the 86th constitutional amendment which made right to education a fundamental right. The state shall provide free and compulsory education to all children of age between 6 to 14 years of age. The right of children to fair, free and compulsory education act was enacted in 2009 to give effect to this right. So everything is clear now. Anyone has any doubt in Article 21 or Article 21A?
No, sir.
So now we will discuss Article 22. Article 22 discuss about protection against arbitrary arrest and detention. No person who is arrested shall be detained in custody without being informed, as soon as may be on of the grounds for such arrest. Every arrested person has a right to be informed of the arrest immediately, consult and be defended by a lawyer of his choice, be produced before the nearest magistrate within 24 hours of arrest. There is an exception to that these protections do not apply to enemy, aliens or persons detained under preventive detention laws, that is UAPA. Preventive detention, detaining someone to prevent a potential future crime, is separately governed by Article 22(4) to 7. Those are exceptions to protection against arbitrary arrest and detention. That is you must have heard about UAPA laws. So nowadays we are discussing. It has been discussed very celebratedly that there is a judgment also, I don't remember the name, wherein we have to provide grounds for arrest. If someone is arrested and is not provided with the grounds of arrest before producing him before the magistrate, अगर किसी को हम अरेस्ट करते हैं और उसको हम ग्राउंड ऑफ अरेस्ट नहीं प्रोवाइड कराते, इवन उसको और उसकी फैमिली को भी प्रोवाइड कराना इंपॉर्टेंट है. अगर हम उसको नहीं प्रोवाइड कराते तो ही इज एंटाइटल्ड टू बेल, एंड सिंपली कोर्ट्स विल ग्रांट हिम बेल इफ grounds of arrest are not being provided to him. The offense can be anything. It can be murder also. Then also he can be granted bail from the court if the grounds of arrest are not provided to him. Many judgments have been given by the Supreme Court and High Courts also. Article 23 and 24. Article 23 talks about prohibition of traffic in human beings and forced labor. Traffic in human beings, beggar, bonded or forced labor, and other similar forms of forced labor are prohibited and punishable by law. The Bonded Labor System Abolition Act 1976 and the Immoral Traffic Act Prevention Act 1956 give effect to these provisions. Article 24 talk about prohibition of employment of children in factories. No child below the age of 14 years shall be employed in any factory, mine, or other hazardous employment. The Child Labor Prohibition and Regulation Amendment Act 2016 extended this to all occupations and processes, not just hazardous ones, though with exceptions for family enterprises and entertainment. So 23 talks about trafficking in human beings and forced labor. 24 talks about child employment below the age of 14 years. Now, right to freedom of religion, Article 25 to 28. I think on last to last session, someone has asked about Sabrimala case. So Sabrimala case is basically depended upon this article only. That is Article 25 and 26. So this talks about religion, practice religion, freedom of conscience and free profession of religion, subject to public order, morality and health. All persons are equally entitled to freedom of conscience and the right to profess, practice, and propagate religion. The state retains the power to regulate the economic, financial, political, or other secular activities of religious institution. State control कर सकती हैं. Suppose वहां पे कोई आप ये देखो कि we call about बालाजी ट्रस्ट और अभी रिसेंटली न्यूज में काफी ज्यादा एक्टिव है दैट इज राम जन्मभूमि केस जहां पे जो उनको चंदा मिलता है whatever donation they received. So audits are being done for that only and these can be regulated by the state कि कोई irregularity तो नहीं है जो चंदा मंदिर में आ रहा है वो प्रॉपरली लग रहा है कि नहीं लग रहा है कहीं चोरी तो नहीं हो रही तो स्टेट कैन मेक पावर्स बट स्टेट कैनॉट मेक लॉज कि आप ये रिलीजन प्रैक्टिस या प्रोफेस नहीं कर सकते. Now we will discuss about Article 26 to 28 in brief. Article 26 talk about every religious denomination has the right to establish institution for religious and charitable purpose to manage its own affairs in matter of religion and to own property. Article 27 talks about no person shall be compelled to pay any taxes for the promotion or maintenance of any particular religion or religious denomination. Article 28 talks about no religious instruction shall be provided in a state funding educational institution. Attendance at religious instruction in a state aided institution shall be voluntary. Now Article 29, cultural and educational right, Article 29 and 30. Article 29 talks about protection of interest of minorities. Any section of citizen residing in India, give me, I have not changed the slide. Article 29 talks about protection of interest of minorities. Any section of citizen residing in India having a distinct language, script, or culture of its own shall have right to conserve it. No citizen shall be denied admission into any educational institution maintained by the state or receiving aid out of the state funds on the grounds of religion, race, caste, or language. So कोई भी किसी भी एजुकेशनल इंस्टीट्यूशन में एडमिशन ले सकता है. स्टेट कैनॉट बाउंड or impose restriction कि you cannot take admission into this college or into this society. This is Article 29. Now Article 30, rights of minorities to establish educational institution. All minorities, whether based on religion or language, shall have the right to establish and administer educational institution of their choice. In granting aid to educational institution, the state shall not discriminate against any educational institution on the ground that it is under the management of a minority. You must have heard about Khalsa College in Diu. सबको पता है खालसा कॉलेज. So it is being managed by Khalsa Group. 6. Everyone is aware about that. So it comes under Diu only. Somehow it is being managed by 6, but it come under Diu only, Delhi University. So this is the example of Article 30. Now we will talk about right to constitutional remedies. Article 32. सबको पता है आर्टिकल 32 क्या होता है. डॉक्टर अंबेडकर डिस्क्राइब आर्टिकल 32 as the heart and soul of the constitution. It guarantees the right to move to the Supreme Court directly for enforcement of any fundamental right. Though it is not encouraged, मैं आपको clearly बताऊं, it is not encouraged to directly approach to the Supreme Court because Supreme Court will not entertain it unless you file your petition before the High Court. When you will file your petition before the High Court and you are not satisfied from the decision, then you will approach Supreme Court under Article 32. So what are the writs? There is a writ called habeas corpus. I have already discussed with you all that, which means produce the body, order the detaining authority to produce the detained person before the court and justify the detention, used to challenge unlawful imprisonment. That means under within 24 hours of arrest, which we just read in Article 22, कि अगर आपको 24 घंटे आपको कोई अरेस्ट करता है, you have been detained by any authority, so they have to produce you before the court within 24 hours and give the reasons for your arrest. Then the other rate is mandamus. We command. That means direct the public body. Yes, Aradhi?
I wanted to ask, sir, that basically, like Article 32 has the power to enforce the writs, basically.
Yes, you can only approach under Article 32 when your fundamental right has been violated.
So, sir, like asking again, I would say that कि जैसे अगर हम एक आर्टिकल हम अगर हमें किसी को मतलब किसी हमें we feel that somebody has violated a fundamental right, so basically writs are those tools we can say that are used to protect our fundamental rights, and Article 32 is a basket kind of protecting all kind of enforcing those tools.
Basically, Article 32 and Article 226 are same. The difference is that under Article 32, you have to approach Supreme Court, and under Article 226, you have to approach the High Court. This is the only difference.
Fair
There is
enough,
no other
sir.
difference. The basket is same. The both contains of 5 writs that are habeas corpus, mandamus, certiorari, prohibition, and quo warranto. Now we will discuss all the writs under Article 32 and Article 226. So Article 32 contains of habeas corpus, produce the body, mandamus, command, certiorari to be certified, prohibition to forbid, quo warranto by what authority? Suppose someone arrests you, so you can challenge that under what authority you have arrested this person. Or if the person is not being produced, then you can file your petition under Article 32 for habeas corpus. So where this person is being detained, produce him before the court. Mandamus, we can file the writ for mandamus when suppose you have any remedy from the that we call state authority, if your property is not being regulated or it is being demolished. Suppose it is being demolished by the MCD, then you can approach court under prohibition to prohibit, or mandamus to give the command to the MCD to stop the demolition. So now we will discuss every writ. That is, first, habeas corpus orders the detaining authority to produce the detained person before the court and justify the detention used to challenge unlawful imprisonment. Mandamus direct a public body, official or inferior court to perform a specific legal duty which it has failed to perform, cannot be issued against the president or state governors. Certiorari to be certified quashes, cancel an order passed by an inferior court or tribunal that has exceeded its jurisdiction or committed an error of law apparent on the face of the record. Prohibition to forbid directs an inferior court or tribunal to stop proceeding that it has no jurisdiction to conduct. Differs from certiorari in that it is preventive, not curative. Q warranto talks about by what authority. Challenge the person's claim to a public office. Questions whether the person has the legal right to hold that position. Now these are the 5 writs. Now what is the difference between Article 226 versus Article 32? Both allows writ petition, but there are differences. Under Article 32 is only for enforcing fundamental rights and is before the Supreme Court. Filing under Article 32 is itself a fundamental right. Article 226 is broader. High Court can issue writs for enforcing fundamental rights and for any other legal right against state or non-state actors within their territorial jurisdiction. So this is the difference under Article 226 and under Article 32. So now we will discuss directive principles of state policies. DPSP, Article 36 to 51. This is the part 4 of the Constitution, contains the directive principles of state policy. Unlike fundamental rights, they are not justifiable. They cannot be enforced in court. However, they are fundamental to the governance of this country, and it is the duty of the state to apply them in making laws. They were inspired by the Irish Constitution and represent India's socio-economic aspirations. Why DPSPs matter? DPSPs क्यों मैटर करते हैं? They represent India's commitment to social economic democracy beyond just political democracy. Courts often use them to interpret fundamental rights broadly. Article 21 expanded using DPSP support. Legislature can restrict fundamental right to implement DPSP subject to basic structure limits. Key DPSPs have led to landmark legislation, that is Manrega, Right to Education Act and Maternity Benefit Act. What are the key directive principles? Article 38. State to promote welfare of people by securing a social order, minimize inequalities. Welfare schemes like Manrega. Article 39 talks about equal pay for equal work, prevent concentration of wealth and means of production. Equal Remuneration Act 1976 is one of the example. The legislation enacted on the basis of Article 39. Article 39A talks about provide. Yes, Ananya, Aina? You have any doubt?
Once more.
38 once more.
Yes.
So basically 38 means state to promote welfare of people by securing a social order, minimize inequality. सपोज जो वेलफेयर स्कीम्स आती है, जैसे आजकल आपने सुना होगा जो स्कीम प्रॉमिस करी गई थी, व्हाट वी कॉल विडो पेंशन. जो विडो पेंशन मिल रही है, दैट इज टू प्रमोट वेलफेयर ऑफ द सिटीजन. जो गवर्नमेंट फ्री डिस्ट्रीब्यूशन ऑफ ग्रेन्स कर रही है, more than I think to more than 80-85 crores of population of the country, that is a welfare scheme that comes under Article 38. So state policy बना रही है for the welfare of the people. Suppose you are getting 200 units of electricity free, 200 units of electricity free, that is also comes under the welfare scheme of the people. Now we will again come to Article 41. Article 39A skip हो गया बीच में. We will talk about now it. Article 39A provide free legal aid to ensure equal access to justice, which was added by 42nd Amendment. It also gave rise to Legal Services Authorities Act 1987. So कोई मुझे बताएगा 39A का मतलब क्या होगा? Free legal aid to ensure equal access to justice. Can anyone tell me? Yes, Aina, you can also tell. You raise your hand.
Sorry, I forgot to lower my hand.
Totally fine. Can anyone tell me about 39A? To provide free legal aid to ensure equal access to justice. So it means अभी हमने लास्ट टू लास्ट सेशन में डिस्कस भी करा था, जो फ्री एडवोकेट गवर्नमेंट को मिलता है, दैट कम्स अंडर फ्री लीगल. My voice is audible to all?
Yes, sir.
So provide free legal aid to ensure equal justice and to access the justice. Article 41 talks about right to work, education, and public assistance in cases of unemployment, old age, sickness. Manrega 2005 and RT Act 2009 is one of the example of it. Article 44 talks about uniform civil code for all citizens throughout India. It has not been enacted yet. अभी तक इनेक्ट नहीं हुआ है, कुछ कुछ स्टेट में हो गया है. सबको पता होगा, उत्तराखंड इज वन ऑफ दैट स्टेट which was the first state to enforce uniform civil code. Article 45 talks about early childhood care and education for all children below the age of 6. Yes, Aina?
So what is uniform civil code?
यूनिफॉर्म सिविल कोड मींस जैसे अभी इंडिया में क्या है कि हिंदूज लॉ, देयर आर डिफरेंट हिंदू लॉज, डिफरेंट मुस्लिम लॉज, डिफरेंट क्रिश्चियन लॉज. So then there will be only single law that will cover the entire society, all the religion. It's called uniform civil law. सबके लिए लॉ एक है. Law will not be different for other people. Civil law, not criminal law. सिविल लॉ सबके लिए एक होगा, क्रिमिनल तो ऑलरेडी एक ही है. सिविल लॉ भी अभी जो डिफरेंट है सबके लिए अलग अलग है, तो वो सबके लिए एक ही हो जाएगा. देन देयर विल बी अ यूनिफॉर्म
Okay, sir.
सिविल लॉ.
Okay, sir.
Article 45 talk about early childhood care and education for all children below the age of 6. That was inserted after 86 amendment. Article 47 talks about raised level of nutrition, standard of living and improvement of public health, food safety and standards act. This is one of the example of it. Article 48A, it was added after the 1976 amendment in the constitution. Protect and improve environment, safeguard forest and wildlife. This was 48A. Now Article 51, promote international peace and security, respect international law and treaties. Indian foreign policy guideline. This is one of the legislation enacted on the basis of Article 51. So what is the key difference between fundamental rights and directive principles? वो कौन मुझे बताएगा? What is the difference after reading everything? Fundamental rights and directive principle. What is the difference between both of them? Who will tell me? Yes, sir, Ade.
So, sir, fundamental rights are basically those rights that are enforced by Part 3 of Indian Constitution and their stated rights in the Constitution. Whereas, talking about DPSPs, there are those policies that are highlighted in Constitution of India that forms the basis on how states should work for the welfare of the people. What type of policies? It basically gives the direction to state do how to work for the people. Whereas one more difference is that fundamental rights are enforced by Article 32 and 226, whereas GPSPs are not enforceable. They are just acting as a we can say background rules, or not rules but background points that can help a state to create its own policies.
Okay. Anyone else? Very good. But coming to this, fundamental rights are negative obligations for the state because they prevent the state from doing certain things like discrimination on the ground of religion. This is one of the example. But directive principles are positive obligations. They require the state to strive towards certain goals. Yes, Aina?
Sir, I just wanted to add a point, but you already said it now, so okay.
So basically, however, both must be read together harmoniously. Now we will discuss public interest litigation, PIL. So PIL is a legal action brought by a citizen or group before the Supreme Court under Article 32 or High Court under Article 226, not on behalf of the petitioner's own personal grievance, but on the behalf of public or disadvantaged group. PILs democratize access to justice by relaxing the traditional rule of locus standi. Locus standi पता है क्या होता है? Can anyone tell me what is locus standi? No one knows what is locus standi.
It's basically, I think, standing alone, basically, or taking a support for something.
No, locus standi means suppose you file any petition before the court. You have to show that what rights are being violated, what your rights are being violated. आपके क्या राइट हैं, बाय व्हाट राइट यू आर हैव अप्रोच दी कोर्ट. सपोज आपके साथ कुछ गलत होता है और मैं जाके कोर्ट में जाता हूँ, तो माई पिटीशन विल नॉट बी एंटरटेन्ड. दिस पिटीशन कैन ओनली बी एंटरटेन्ड अंडर PIL. when is a group of people being affected by certain action of the government or for certain omissions of the government, then the person can approach the court under PIL, and his local standi cannot be questioned by the court. Otherwise, if you file any petition, then the court will ask you what is the locus standi, what rights of yours being violated, why you have approached this court, why that person has not approached this court. Under PIL, when there is a certain group of people whose rights are being affected and the other person approached the court under PIL, MC Mehta was one of the person who approached the court when there was certain environment environment was not being protected by the government, by the state. Then he approached the court. Thereafter, it was made a fundamental right to free air, clean air, free of pollution. So this was the example of locus standi. So locus standi is not questioned under PIL, which required that only the aggrieved party could file a case. The concept of PIL was developed by the Justice P.N. Bhagwati and Justice V.R. Krishna Iyer in the late 1970s and 1980s as a tool of judicial activism to protect the rights of the poor, marginalized and voiceless. जो लोग अपने लिए नहीं बोल सकते उनके लिए सिटीजन्स आपको 1976 में काफी चीजें हुई थी, काफी डायरेक्शंस आए थे, हमारे जो भी फंडामेंटल राइट्स से इमरजेंसी का सिचुएशन था, वो सारी चीजें 1970 से 1980s के पीरियड में हुई थी. देन ओनली पीआईएल हैव डिवॉल्व. उसके बाद ही पीआईएल का कल्चर आया था, उसके बाद ही पीआईएल फाइल होना स्टार्ट हुई थी. उसके बाद ही सारी चीजें जो कोर्ट ने डिसीजंस दिए हैं, वेदर इट इज विशाखा केस जिसमें पॉश का बाद में जाके पॉश का जो लॉ इनेक्ट हुआ था, और अदर केसेस वी विल डिस्कस आफ्टर दिस ओनली. सो हाउ पीआईएल डिफर्स फ्रॉम ऑर्डिनरी लिटिगेशन. हु कैन फाइल? ऑर्डिनरी लिटिगेशन में ओनली द एग्रीड पार्टी स्ट्रिक्ट लोकस स्टैंडी कैन फाइल. एनी पब्लिक स्पिरिटेड इंडिविजुअल, एनजीओ, जर्नलिस्ट और ग्रुप ऑफ पीपल इवन ऑन बिहाफ ऑफ द अदर कैन फाइल पीआईएल. पर्पस क्या है? ऑर्डिनरी लिटिगेशन में रिड्रेस आ पर्सनल ग्रीवांस, और पीआईएल में क्या होता है? प्रोटेक्ट पब्लिक इंटरेस्ट, फंडामेंटल राइट्स और डिसएडवांटेज ग्रुप्स. कोर्ट के अकॉर्डिंग क्या होगा? एज पर सिविल क्रिमिनल जुरिडिक्शन. बट पीआईएल में क्या होता है? यू कैन डायरेक्टली अप्रोच हाई कोर्ट और सुप्रीम कोर्ट. सिविल कोर्ट में ये केसेस नहीं चलते, पीआईएल फाइल नहीं होती. कोर्ट फीस अगर आप ऑर्डिनरी लिटिगेशन में देखोगे तो सिविल में सिविल लॉ के अकॉर्डिंग चलती है, बट इसके अंदर क्या होती है? मिनिमम नॉमिनल होती है विच इज अराउंड 100 और 50 रुपीज. ओरिजिन क्या है? डेवलप्ड बाय इंडियन जुडिशरी इन 1970s and 80s फ्रॉम आर्टिकल 32. Now again we will discuss. Everything is clear to everyone. Who can file? Any citizen or group of people can file PIL. Even a postcard to the Supreme Court can be treated as a PIL. An NGO, journalist or activist, no requirement of locus standi in traditional sense. Which court we will approach? Under Article 32 Supreme Court, Article 226 High Court. Cannot be filed in district court. Must involve public interest, not private grievance. What relief we will sought? Writ to mandamus directing the state action. Structural injunction to reform institution. Compensation to victims. Policy direction to government bodies. So these, if you will go through the below section of the slide, PL milestones, these are the celebrated cases. That is Husnaira Khatun, MC Mehta, Vishaka, and Puttaswamy. Now we will discuss all these cases. What is Husnaira Khatun and State of Bihar? This was a judgment given by the Supreme Court. A newspaper revealed that thousands of under trial prisoners in Bihar jails have spent years in custody, in many cases longer than the maximum sentence for the offense they were accused of. A PIL was filed on their behalf. What was the issue involved in that petition? Does prolonged incarceration. Incarceration का मतलब होता है जेल में रहना, उसे हम incarceration बोलते हैं. Prolonged क्या होता है? कि जितना उनको सेंटेंस था उससे ज्यादा they have already spent their time in the jail. Of under trial. Under trial क्या है? कि उनका केस अभी डिसाइड नहीं हुआ है. It is yet to be decided by the court. Without trial, violate the right to life and personal liberty under Article 21 of the Constitution. The Supreme Court held that the right to speedy trial is an integral part of Article 21. The state was ordered to release all under trial prisoners who had been in custody for the period exceeding the maximum permissible sentence for their alleged offense. Significance क्या है इसका? First major PIL in Indian history established that Article 21 right to life includes the right to a speedy trial, transformed PIL as a tool for social justice, led to legal aid reforms. Anyone have any question for this judgment? Can ask me.
सर कुड यू प्लीज टेल इट वंस अगेन, मतलब समझ आ गया बट थोड़ा सा एक बार बता दोगे तो क्लैरिटी आ जाएगी।
क्या समझ नहीं आया मुझे बताओ आप, मैं बताऊंगा आपको।
सर जैसे कि मतलब इसमें ये तो समझ आ गया कि पीआईएल का इसने काफी बेस स्ट्रॉन्ग किया था, बट वो प्रोसेस कैसे हुआ था वो एक बार थोड़ा सा बता दो।
प्रोसेस देखो, सिंपल सी बात है। बिहार में क्या होता था, स्टेट ऑफ बिहार में क्या हुआ था कि काफी सारे जो अंडर ट्रायल प्रिजनर्स थे वो रिलीज नहीं हो रहे थे, उनका ट्रायल नहीं हो रहा था कोर्ट्स में, वो सिर्फ जेल में पड़े हुए थे, उनकी कोई सुनवाई नहीं थी, नो वन वाज लिसनिंग टू देम, एंड दे हैव ऑलरेडी सर्व द पनिशमेंट फॉर द ऑफेंस दे हैव कमिटेड। सपोज उन्होंने चोरी करी है, चोरी के अंदर अगर आपका 3 साल का पनिशमेंट है तो दे हैव ऑलरेडी सर्व दैट पनिशमेंट। 3 साल से ज्यादा उनको 4 साल 5 साल हो चुके थे। इन केस यू कैन से 420 में 7 years की पनिशमेंट है तो दे हैव ऑलरेडी सर्व 7 years ऑफ पनिशमेंट एंड मोर देन दैट, and still their trial has not been completed or concluded. So for all these types of category of persons, a PL was filed before the Supreme Court. Ki look, these people have already served their sentence and their trial has not yet been concluded. So this was the reason this PIL was decided by the court, and it said that right to speedy trial is one of the part of Article 21. So then all the people who have already completed their sentence were released by the from the jail by the jail authorities or by the state government. और किसी का डाउट है इसमें या क्लियर है? यू कैन मूव फॉरवर्ड। किसी को कोई डाउट है तो यू कैन आस्क मी राइट नाउ। यस लोकाबे, लोकाबे योर वॉइस इज नॉट ऑडिबल। नेक्स्ट, that is MC Mehta versus Union of India. So this was the oleum gas leak from the Shriram Food and Fertilizers plant in Delhi, December 1985, killing one advocate and injuring hundreds. Environmental lawyer MC Mehta, he have, I think, died this year or last year, late 25. Advocate and injuring 100. Environmental lawyers MC Mehta filed a PL to shut down the plant and claimed compensation for the victim. This case was basically taken after that Bhopal gas tragedy. So, should a rule of strict liability apply to industries engaged in hazardous activities? Can court award compensation in writ jurisdiction under Article 23? So, what was the issue involved? जब MC मेहता जी ने PL फाइल करी थी बिफोर ओलियम गैस लीक, तो उससे पहले क्या था? एब्सोल्यूट लॉ नहीं था, लाइबिलिटी नहीं थी एब्सोल्यूट लॉ की। absolute liability was not there कि who will be responsible if anything takes place from the hazardous factory which are doing the business of hazardous like chemical processing होती है, सारी चीजें जहाँ पे होती है, जहाँ पे chemical treatments होते हैं, if something mishappens from that place, so who will be responsible? So after this case it was held that there is a concept called doctrine of absolute liability which came into picture. तो सुप्रीम कोर्ट ने ले डाउन क्या करा था? द सुप्रीम कोर्ट लेड डाउन द डॉक्ट्रिन ऑफ एब्सोल्यूट लाइबिलिटी, डिपार्चर फ्रॉम रायलैंड्स एंड फ्लेचर, एन एंटरप्राइज engaged in hazardous activity is absolutely liable to compensate all affected persons, no exceptions, no defenses whatsoever. सपोज कोई भी फैक्ट्री चलाता है जिसमें hazardous activity इन्वॉल्व है, वो कहता है कि मेरी वजह से ये नहीं हुआ है, तो कोर्ट ने क्या ले डाउन करा था कि इफ एनीथिंग हैपेंस आफ्टर दिस केस then you will be liable. You cannot take a defense that I am not liable, someone else is liable. It's your duty to compensate all the victims. So what was the significance? Article 21 includes the right to a pollution free environment, established absolute liability as Indian tort law standard, led to Environment Protection Act 1986 and NGT, National Green Tribunal 2010, precursor to the Bhopal gas tragedy compensation debate. So this was filed after 1 year from the Bhopal gas tragedy case. Anyone has any doubt in this? Or we can move forward?
Sir, can you explain about the landmark doctrine which you told about? Doctrine of what was it?
Your voice is not audible properly. You're saying doctrine of?
Sir, which doctrine were you talking about exactly? I couldn't understand.
You can read this landmark doctrine here. Absolute liability. Under this liability, you are liable to compensate. Under this liability, absolute liability, you cannot take any defense that this has not happened because of me. This has happened because of someone else. This means absolute liability. You are being charged with that you are responsible for it. It means doctrine of absolute liability. Whatever takes place in this factory or under this premises will be your responsibility. This is known as absolute liability. आप अपना
Sir,
डिफेंस में नहीं ले सकते कि आपकी वजह से नहीं हुआ है, ये किसी एम्प्लॉय की गलती है या किसी स्टेट अथॉरिटी की गलती है. इफ यू आर रनिंग अ फैक्ट्री और इट हैज बीन involved into any processing of hazardous activity, then you, if any mishappening takes place from your factory or premises, then you will be responsible for it. So hazardous में क्या हो गया आपका? Suppose any chemical factory, any firecracker factory, all this comes under hazardous activity.
so nowadays, पहले के टाइम में there was that child labor रहता था for firework factories, I guess.
I think your voice is not audible properly. Can you be loud?
I was saying that in firework factories पहले child labor हुआ करता था. So अगर हम उसमें देखा जाए कि कोई बच्चा hurt हो गया तो उसमें भी is that kid liable on the employer?
Yes, definitely he will be liable for that. First of all, he will be prosecuted for employing a child labor. That is a separate thing. Then if any mishappening happens to him, then also he will be liable for that. And then he cannot take a defense that I am not responsible for it, someone else is responsible for it. Clear? Now we will talk about Vishaka and others versus state of Rajasthan. This was the this is one of the most important and celebrated judgment. And after 1997, I think in 2013, a law was enacted on the basis of this judgment that is called POSH, Prevention of Sexual Harassment at Workplace. Prior to that, from 1997 till 2013, this judgment was followed by all the corporate entities in our country. So, Bhanwari Devi, what were the facts? Bhanwari Devi, a social worker in Rajasthan, was gang raped in 1992 after she opposed a child marriage in her village. The accused were acquitted. No specific law existed in India on workplace sexual harassment. Women's rights groups filed a PIL. What was the issue involved in the PIL? Does the absence of law on workplace sexual harassment violate fundamental rights? Specifically, Article 14, 15, 19, 1G, and Article 21. What duties do employers have? Decision क्या हुआ था? विशाखा guide. There were certain guidelines. After hearing to the parties, the Supreme Court laid guidelines. The guidelines was that the Supreme Court laid down the Vishaka guidelines as binding law under Article 141, applicable to all workplaces until Parliament enacted legislation. Guidelines required employers to prohibit sexual harassment, establish complaint committee, take disciplinary action. क्या हुआ था इसके अंदर? हम दोबारा एक बार पढ़ेंगे कि सबसे पहले बनवारी देवी थी, उसके साथ गैंग रेप हुआ था when she opposed child marriage in her village. Thereafter, certain group of people filed the PIL before the Supreme Court to enact a law because there was no law prevailing at that time regarding the protection of the rights of the women and what duties do employers have towards their employees. तो सुप्रीम कोर्ट ने गाइडलाइंस ले डाउन करी थी that we called it Vishaka guidelines. Under those guidelines, it was made mandatory to prohibit sexual harassment in the organization. First, the second was to establish complaint committees. In complaint committees, there were 3-4 members, and out of them, 1 or 2 members should be female members, where you can report if any harassment has taken place with you and take disciplinary action. the committee has to take disciplinary action after hearing to the party. The committee will give opportunity to hear to the person who have raised the accusation and against whom the accusation has been raised. Then if committee thinks that there is something happened or not, according to that they will proceed and they have to decide whether they need to take any disciplinary action or not. What was the significance of this judgment was that pioneering use of international CEDAW conventions to interpret Indian fundamental rights established that sexual harassment equal to violation of Article 21. The Vichaka guidelines were codified as the POSH Act, Prevention of Sexual Harassment at Workplace Act 2013. This act was enacted on the basis of these guidelines. Everything is clear to everyone now? Or anyone has any doubt regarding this judgment? Now we will discuss last case law, that is K.S. Puttaswamy versus Union of India. This is the most recent one. Justice K.S. Puttaswamy, retired justice, he was a retired justice, challenged the Aadhaar biometric identification scheme, arguing that it violated citizen privacy. The government contended that privacy was not a fundamental right, relying on older judgments given by the Supreme Court, that is MP Sharma 1954 and Kharak Singh in 1962. The issue involved in this judgment was, is privacy a fundamental right under the Indian Constitution? Does it form part of Article 21, right to life and personal liberty? The decision given by the court was that there was a bench which was formed to decide this judgment was of 9 judges. All 9 judges unanimously held that privacy is a fundamental right intrinsic to Article 21. The court overruled MP Sharma and Kharak Singh. Privacy encompasses bodily integrity, decisional autonomy, and informational self-determination and dignity. What was the significance of the judgment? Changed Indian constitution law forever. Implications for Aadhaar, surveillance, LGBTQ committee rights led to Navtej Johar 2018 discriminalizing Section 377 that has taken place after this judgment only. Data protection legislation and every citizen's right against state intrusion. So इसमें किसी का कोई डाउट है और आई विल एक्सप्लेन अगेन दिस जजमेंट टू ऑल ऑफ यू. Anyone has any doubt regarding this judgment or anyone wants to ask any question from me?
Clear, sir, clear.
क्लियर है सबको? मैं फिर भी आपको दोबारा यार बताता हूँ. इस जजमेंट में एक रिटायर्ड आपके के.एस. पुट्टास्वामी वाज अ रिटायर्ड जस्टिस. उन्होंने हाई कोर्ट सुप्रीम कोर्ट को अप्रोच करा था. ही फाइल्ड पीआईएल कि आधार जो है हमारी प्राइवेसी को वॉयलेट कर रहा है. बिकॉज आधार से क्या होता है कि आपको सारे इंफॉर्मेशन का एक्सेस मिल जाता है गवर्नमेंट में. आज की डेट में आधार को हर जगह गवर्नमेंट उस टाइम पे इंट्रोड्यूस कर रही थी. तो ही फाइल्ड अ पिटीशन बिफोर द सुप्रीम कोर्ट दैट लुक, आधार थ्रू आधार कार्ड government is trying to violate a right to privacy. And prior to this judgment, it was decided that right to privacy was not a fundamental right under this constitution. So 9 जजेस की बेंच फॉर्म हुई थी. उन्होंने ये डिसाइड करा था पुरानी जजमेंट को ओवररूल करते हुए कि यस, राइट टू प्राइवेसी इज ऑल्सो अ इंटीग्रल पार्ट ऑफ फंडामेंटल राइट्स एंड इट डिक्लेयर्ड दैट इट इज अ पार्ट ऑफ फंडामेंटल राइट्स अंडर इंडियन कॉन्स्टिट्यूशन. उसके बाद ही अभी आपने रिसेंटली देखा होगा तो जो हमारे प्राइम मिनिस्टर है नरेंद्र मोदी जी, उनके केस में भी जब उनकी एजुकेशनल क्वालिफिकेशन पूछी जा रही थी बार बार फ्रॉम द आम आदमी पार्टी बिफोर द दिल्ली हाई कोर्ट. सो दिल्ली हाई कोर्ट रूल्ड दैट एज पर द केएस पुट्टास्वामी जजमेंट, it is his personal information which cannot be leaked in public. Nowadays this judgment is very much celebrated and used everywhere as a right of privacy. It was a right of privacy of Mr. Narendra Modi that his personal qualification cannot be declared in the public or cannot be intimated to the public. It can be questionable whether his education is his personal privacy or everyone is basically entitled to know how much educated is his prime minister. But court held that Delhi High Court held that look, this is his personal information which cannot be provided under RTI because RTI was filed by the few people of the Aam Aadmi Party. Everything is cleared, and they after this judgment only the LGBTQ judgment came into picture, and 377, which was decriminalized. This was after that only, after this judgment only. Anything else? Now we will discuss the comparing the four landmark judgments. Husnaira Khatun, it was the year in 1979. MC Mehta, 1987. Vishaka versus Rajasthan, 1997, and Puttaswamy 2017. Issue involved under trial prisoners in custody, then max sentence. Fundamental right, Article 21, right to free speedy trial. Key outcome, release ordered legal aid reforms. Then thereafter, MC Mehta, this was the oleum gas in Delhi itself. Give me a moment. MC Mehta oleum gas leak, 1987, from industrial plant liability, Article 21, right to clean environment, absolute liability doctrine, no exceptions. Vishaka versus Rajasthan, 1997, no law on workplace sexual harassment, Article 14, 15, 19G, and 21 were involved. Vishaka guidelines, later POSH Act 2013 was laid down. Puttaswamy 2017, Aadhaar and right to privacy, Article 21, privacy as fundamental right. 9 judge bench privacy held that privacy is a fundamental right. What was the common thread between all the four judgments? Article 21 interpreted broadly in all the four cases. PIL as a tool. All four were PILs filed on behalf of voiceless groups. Article 141. All Supreme Court decisions are binding precedent on all groups in India. Social impact. Each case led to directly legislation or policy change. Everyone has to do one thing before coming to that. I will discuss few definitions with you. What is definition of state? Can anyone tell me what is the definition of state? Who will tell me? Who will tell me what is the definition of state? No one knows. Basically, state includes union, states, local authorities, and other instrumentalities which binds the state. Everything comes under the state only, whether it is the union government, state government, local authorities, or other instrumentalities. What is the definition of void laws? कोई बताएगा मुझे void laws क्या होते हैं? Any law inconsistent with fundamental rights is void to the extent of inconsistency. Includes pre-constitution laws. Equality before law, everyone knows no person shall be denied equal treatment, intelligible differential doctrine. No discrimination on the ground of religion, sex, caste, place of birth, exceptions for women, children, backward classes. Equal opportunity in employment. In public employment allows reservation for backward classes, SCs, STs, and economic weaker society section. Abolition of untouchability, enforceable criminal offense, protection of civil rights, Acts 1955. Article 18 talks about no titles, no state conferred title except military academic citizens cannot accept foreign title. Article 19 talks about 6 freedoms, that is speech, assembly, association, movement, residence, profession, subject to reasonable restrictions. Article 20 talks about criminal protections. No ex post facto, no double jeopardy, no self-incrimination. Article 21 talks about right to life and liberty. Most expensive fundamental rights include privacy, speedy trial, clean environment, dignity, health. Right to education, it was enforced by the amendment 86 amendment in 2002. Free and compulsory education for the ages of 6 to 14. Article 22 talks about protection from arrest in form of ground, right to lawyer produced before magistrate in 24 hours. Article 23 talks about no forced labor, prohibits traffic in person, beggar, bonded labor system, abolition act 1976. Article 24 talks about no child labor, no child under 14 in factory, mine or hazardous work. Article 25 talks about religious freedom, freedom to conscience, profession, practice and propagation. Article 26 to 28 talks about religious institution, manage affairs, no text for religion, no religious instructions in state schools. Article 29 to 30 talks about minority rights, conserve cultural, establish and administer educational institutions. Article 32 talks about constitutional remedies, heart and soul. There are 5 writs involved in it. We have already discussed habeas corpus, mandamus, surgery, prohibition, and quo warranto. Now everyone has to do, this is the second assignment of our class, that is mock PIL petition. Everyone have to draft a mock PIL petition on any real social cause issue that interests you. Your PL must be structured and legally sound. Everyone can read the slide over their screen. Name the individual organization filing the PL and state authority being challenged. Statement of fact. Describe the problem clearly with factual details. Who is affected, how, and to what extent. Fundamental rights. What fundamental right is being violated. Identify the specific article being violated and explain the connection to the facts. Legal ground. State why the state's act or omission is unconstitutional. What is the prayer? Specify exactly what you want the Supreme Court to order. Be specific and realistic. Understood, everyone? Anyone has any doubt?
Sir, I actually wanted to ask that, like, do we have to make it by a specific template, or like it can be in any form?
It can be in any form. You can basically do one thing. You can get a draft of the PIL from the Google, and in that form you can draft your PIL.
We can search a template from Google.
Yes, but
Fair.
don't use AI to draft the PIL. Remember this thing.
No issues, sir.
Remember this thing. Don't use AI, ChatGPT to draft your PIL. Use your mind. After reading that the PIL, I can get to know whether you have drafted it on your own or you have drafted it from any AI. Yes, Aina, what is your question?
So I wanted to ask that we have to submit in this classes, you know, that side option, submit assignment.
Basically, where you have submitted the previous assignment, you have to submit it there only.
Sir, I asked you last class also what to do in the first assignment, so I don't know where to submit it.
You don't know where to submit it. I will ask the coordinator to communicate with you where you have to submit it. Don't worry.
Okay.
Sir, have you like saw our earlier assignments?
I have not saw it, yes, because I am right now busy in my personal commitment, and I have given. I think you must have all have got the link to view the proceeding of the Supreme Court. I have provided the link.
Yeah, that Vivek's one.
Everyone has
So
saw
where
the
have you
proceedings.
given?
You did not received it.
So where have you given? Where have you shared it?
I have shared with the coordinator of this, basically RiarPro, whether you have received it or not.
Received
No,
it, sir.
sir.
You have received it. Where you have received it? Can you
It
inform
is
us?
in the law internship group.
Sir, I am not in that group.
You are?
I am not in that group.
You are not in that group. Don't worry. I will ask the coordinator to add you in that group.
Okay.
And anyone have any question now? So briefing up this class, this session, what we have come to know today, the Supreme Constitution is supreme. DPSPs are the aspirational goals. Article 21 is the most expensive right. There are six categories of fundamental rights. PIL democratize justice. Case laws are the law. Understood? This is a very brief thing to say that case laws are the law. We will discuss this on a later day. Don't worry. Thank you, everyone. Anyone has any doubt can ask me in the next class.
Bye, sir.
Bye bye.
Bye, sir.
Thank you very much.